If an author does something that reflects poorly on them and the publisher that they're associated with, can the publishers drop that author? Let's talk to an IP and entertainment lawyer to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
So, Tony, let's talk about what happens when an author does something that reflects poorly on themselves personally and poorly on the publishers that they are working with. Can you talk to us about the legal perspective of this? Can publishers just up and drop those writers?
So the answer is yes, conditional to whether or not the agreement that exists between an author and a publisher contains what is called a morals clause. You probably have heard this terminology thrown around with, mainly in the entertainment space. But a morals clause is actually one of the most important clauses to have in a contract, especially if you're dealing with a big name personality. So essentially the function of this clause is that it allows the publisher, or in this case, or brand X, to back out of a deal, to terminate the deal with or without reason, no questions asked, if the person on the other end of the deal has engaged in any activity that is scandalous, immoral, deceptive, illegal, or otherwise criminal. And again, very commonplace in the celebrity space when celebrities are working with brands, with companies, corporate entities, what have you. And this basically creates that safeguard for the brand that if said athlete or said celebrity does something that rises to the level of being scandalous, there you go. Or, they can back out of it. Or if they did something that's illegal, they can go ahead and back out of it. So what does that look like? If, let's say, celebrity X was involved in a DUI, that could even be enough for a determination of the contract under the morals clause. Even if they were tried or not, let's say the fact that someone was arrested for a DUI could be enough of a triggering event for the morals clause to kick in. If someone, let's say, was convicted of a crime, that's something that could also give rise to a termination of a contract. Just to kind of give some color commentary to this, there was an athlete back in 2013 named Aaron Hernandez who used to play tight end for the New England Patriots, was a star in every sense of the word, and was signed on to be the spokesperson for Muscle Milk. In the summer of 2013, Aaron Hernandez was a person of interest among police in Massachusetts after Aaron Hernandez's friend Odin Lloyd went missing for an extended period of time, and there was no trace of him. And then it turned out he was murdered, and his body was found in kind of like a landfill area. And when police approached Aaron Hernandez asking for information and for evidence, he had actually destroyed all of his security camera footage. He destroyed his cell phone that potentially had cell phone records showing his calls with Odin Lloyd, and he had abandoned a rental car that had the body of Odin Lloyd in that dumpster area. So in effect, he had committed what was called obstruction of justice, and he was arrested and charged with that initially before ultimately police were able to connect him to the murder. Now, I'm mentioning this story because initially he was only being charged with obstruction of justice, but was not convicted. This is well before he even got the murder charge in the Commonwealth of Massachusetts. But just because there were photos of him showing him with his white t-shirt on, red shorts on, I'll never forget the image, with his back behind him and being escorted by two cops, Muscle Milk said that is going to lead us to terminate his contract with Muscle Milk. This is a violation of the morals clause. Just the mere arrest was enough of a triggering event for them to terminate that relationship. But meanwhile, you have a very recent example, Jonathan Majors, who's an actor who recently starred as Kang the Conqueror, the new super bad villain in the Marvel Cinematic Universe. He was initially charged and he was charged with domestic violence in March, right after the release of Ant-Man 3, where he made his debut as Kang the Conqueror. Initially when he was arrested and charged with domestic violence, he had a deal with the Texas Rangers to do an ad campaign for them. They pulled that deal. Violation of the morals clause. He had an ad campaign with Army that had already released, and 1 week in, Army pulled that ad, likely because he had a morals clause there that the arrest and the charge triggered that event. But meanwhile, Marvel Studios let him basically stayed on the roster for Marvel Studios for an extended period of time up until the trial. And when he was convicted, the same day that he was convicted for and found guilty of aggravated assault, that's when Marvel Studios said, we're kicking in the morals clause, and this is the trigger event. So the problem with morals clauses, as I'm laying out all these examples, is that it could be any event, any triggering event. And that's unfortunately the case with any sort of agreement that takes place with whether you're talking about author to publisher, brand with celebrity, whatever it is. It's open for interpretation. So it's not an objective analysis. It's purely subjective. It's based on what the brand wants. So in light of this, if you're an author and you're working with a publisher where they have the inclusion of a morals clause, I would obviously make a reference to a few points. First, hire a publishing lawyer immediately. Obviously, you may not have knowledge of reading a contract, but a publishing lawyer does, and they're aware of kind of the clauses that protect you and your rights as an author. So it's very important to have an advocate on your side to help you anyway. But two, the reason why you want a publishing lawyer is because they'll help you amend maybe the terminology of a morals clause. Maybe they will define a little bit more clearly what the trigger event is that will kick in a morals clause that will allow a publisher to say, we're done with this author. But number three, a publishing lawyer is also going to be very helpful because now at this point, you can have your lawyer maybe insert what's called a reverse morals clause, meaning what if publisher does something that is illegal, scandalous, immoral, deceptive, or criminal? What if they do something that leaves a bad taste in your mouth that allows you to then kick in the morals clause and say, you know what, I'm going to back out of this deal with publisher because they did something that it qualifies as a trigger event under the morals clause. We saw this in light of the FTX scandal where it was this cryptocurrency scam and tons of celebrities endorsed it and now are being personally sued by investors of FTX, saying that they were duped by these celebrities and whatnot. Now, obviously, these celebrities and athletes that endorsed FTX had no knowledge of what was happening behind the scenes with FTX, with all the money laundering and the wire fraud and all that was happening, all the fraudulent activity that was happening behind the scenes. So bottom line is, as a result of the FTX scandal, a lot of athletes and celebrities are now incorporating reverse moral clauses to protect themselves as well. And I think that that's an extremely wise move. So if you're a publisher, or if you're working with a publisher and you're an author that has, X amount of experience, you have a fairly big following, you're fairly recognized in your industry, maybe the reverse moral clause will be beneficial to you because that is just another safeguard for you to protect your rights as you work with a publisher. So all in all, morals clauses are fairly straightforward. They're not the kind of things, not the kind of clauses that are open for ambiguity. They pretty much are cut and dry. Obviously, what is the tricky part with them is the triggering event that kicks in the morals clause, but it is basically and fairly black and white. But having a lawyer help you navigate the world of understanding a morals clause and protecting you inevitably is the name of the game when you're dealing with said clause in the negotiation phase with the publisher.
Now, as we're reading through our contracts, Tony, are we going to see a specific section on the morals clause, or is that going to be tucked somewhere under a termination clause?
So that's a great question. And I would say probably it's going to be either above or maybe, it's not really either or. It's going to be somewhere near the termination clause. And normally, morals clauses are their own standalone clause. And I think that's mainly because the termination clause may have some type of specific verbiage that will say something like, if you want to terminate this agreement, you have to give notice within 14 days, 21 days, 30 days, whatever it is, and basically lays out the parameters that would allow the lawful termination of a contract between a publisher and an author. But the thing with morals clause is, literally in a split second, you can cancel that contract because of the illegal, scandalous, immoral, deceptive activity that may take place. And it's a unilateral clause at that point. So really, it's up to the publisher to say, hey, we're going to terminate because he said something on Twitter that we didn't like, that was fairly scandalous from a political point of view. He made political speech, and obviously that raises a whole different ballgame, free speech. But at the end of the day, a publisher operates as a private employer. Maybe they're able to do something like that. But nonetheless, it could be that. It could be, again, an arrest. It could be a conviction in trial. All of those can serve as the trigger event that doesn't require the advance notice. They just do it and they call it a day.
And this is why it's so incredibly important to make sure you have a publishing lawyer look over your contract before you sign it, not after, retroactively, when you have to defend yourself. So make sure you've got that publishing lawyer looking over it before you sign it. Make sure things are as spelled out as possible, and make sure you can try to include that reverse morals clause, because we know there's a lot of things that go down in the publishing industry, some that we hear about, some that we don't. You want to make sure you are protected as things begin to unfold in your author career as well. If you've got questions on the legal side of publishing, go ahead and drop those down below, because Tony's coming back for upcoming episodes. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called End Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below. Tony's going to be back for upcoming episodes, and we're spending every single day dropping a new episode to help you navigate the world of publishing, from your writing to your publishing to your marketing, to make this your most profitable year ever without the time and stress commitments. We'll see you in the upcoming episodes.